Good afternoon, ladies and gentlemen. We're so glad that you're with us today. Our webinar is now beginning. I'm Steve Love, President, CEO of the Dallas-Fort Worth Hospital Council. We're glad you're joining us today for this educational webinar that's hosted in coordination with Hall Renda, who is an associate member of the Dallas-Fort Worth Hospital Council. Today's topic is Stark Law, back to basics. And I know we're all familiar with Stark, but it's probably good to go and refamiliarize ourselves, especially in the current environment. We've really been looking forward to this presentation. We've got a great panel of national experts, and they're going to discuss not only some of the key definitions, exceptions, penalties, what happens for non-compliance, but some of the trends and compliance strategies for overall healthcare organizations. Our speakers today include Keith Duggar, Alyssa James, Katherine Schwartz, and Kerry Dutra. All of them are attorneys with Hall Renda, and they have a collective years of much experience. They assist clients from across the U.S., not only hospitals, but health systems, physicians, physician groups, ancillary service providers, and others, not only navigating the legal part, but the operational challenges that all of us face in our industry. I think many of you know Keith. He's been a past speaker here at the DFW Hospital Council in previous educational events. He is headquartered here in Dallas, and he has over 20 years of experience. And the other people, as they talk and introduce, can certainly give their location of where they are. But one final thing I do want to tell you, if you have questions, please put them in the question box or the chat box, and we'll relay these to the speakers. With that said, and without further ado, it's my privilege to turn this over to Keith Duggar. Keith, take it away.
Thank you. Thank you, Steve. I really appreciate that. And thanks to everyone for joining in today. We really appreciate you listening to our Stark Law Back to Basics webinar. Before we get started today, I wanted to give you just a brief outline of our agenda and let you know who is speaking today. As Steve mentioned, Kerry Dutra, she's in our Raleigh office. She's going to talk first about why we care so much about Stark compliance and briefly describe the Stark Law and its enforcement landscape. Next, we have Katherine Schwartz. She's out of our Indianapolis office, and she and I will guide you through some of the Stark Law basics, including a discussion of key definitions, exceptions to the general Stark Law prohibition, and group practice issues. Alyssa James of our Indianapolis office will then provide a helpful overview regarding the big three concepts of fair market value, commercial reasonableness, and the volume and value standard. Finally, Katherine will provide an overview of key case law developments and trends in Stark Law enforcement. As Steve mentioned, we're also going to reserve some time at the end to respond to questions from the audience. So please make sure to submit any questions that you have as you listen in. And now I'll pass it off to Kerry.
Thanks, Keith. So as we get started here, perhaps, and maybe the most important question of the day is, why do we care so much about the Stark Law? And one of the key reasons is just the enforcement landscape that we are in the healthcare industry, particularly in the realm of fraud and abuse and Stark. So I'm sure many of you know prosecuting, alleged fraud is good business for the government. For about every dollar that they invest in fraud and abuse enforcement, they get about $4 back. That is from, I know on the bottom of your screen there, you're seeing July 2021 report numbers, but it's about a 1 to 4 return based on the numbers that just came out in July of 2022. So we don't see this going away anytime soon, given this is, a big money maker for the government to have enforcement here. And so that leads us naturally into really the second piece of why we care so much, and that is that violations of Stark, even when they're minor technical violations, can lead to pretty steep penalties for healthcare organizations and physicians. So some of these penalties can look like required refunds of monies paid by the federal healthcare programs, so Medicare and Medicaid, to an organization. They can include sanctions from the Centers for Medicare and Medicaid Services. So those are financial penalties, and then the big trigger, potential exclusion from participation. And then lastly, we have, for Stark violations, potential False Claims Act liability. And my colleague Katherine is going to touch a bit more about the False Claims Act, or the FCA, a little bit later in the presentation. But for purposes of Stark, violations under Stark can really serve as the basis for a qui tam or whistleblower, FCA suit, or a government-initiated suit. And with the FCA, that brings even steeper financial penalties. We're looking at per claim fines of upwards of 20,000 plus treble damages of the monies back to the government. So now that we have kind of framed up why we care and done a little bit of the scary intro slides, we can really get into the nitty-gritty of what Stark law is. So just to kind of put the basic overview in everyone's minds as we work through the definitions, the Stark law makes it a civil offense for a physician or their immediate family member to have a financial relationship with an entity and refer to that entity for a set of healthcare services called designated health services, which are payable in whole or in part by Medicare or Medicaid. And this prohibition is in place unless this financial relationship meets an enumerated exception under the Stark law. So in a few slides, Katherine and Keith will get into those exceptions. One thing to note, and really one of the tangents to why we focus so much on the details about Stark, is because it is a strict liability statute, meaning there isn't any intent element to it. It is not like anti-kickback, where you have an argument that you did not have the requisite intent. Here it is, if there is something wrong with the relationship, if it is not meeting every element of an exception, it is a relationship that is per se improper. So for this highly technical nature, this is really why we spend so much time in these key definitions, in the basic elements of the exceptions, and going over them and making sure we understand them, and really getting back to the basics. So Keith, if we can go to the next slide here. And one more forward, thanks. The first definition we're really going to get into in this far left bubble is the physician or immediate family member piece. When we think about what is a physician, this is probably pretty in line with what most folks think generally when they think of a physician. Stark law defines it as MDs, DOs, dentists and oral surgeons, podiatrists, optometrists, and chiropractors. When we get into immediate family member, this may be where someone's lay definition is a bit different than what Stark says. Stark has a pretty broad immediate family member definition. So that includes people like spouses, natural and adoptive parents, siblings, step-siblings, grandparents, grandchildren, and in-laws, so spouses of those folks, are all immediate family members under Stark. So if we go to the next, thanks, Keith. The second bubble here is we have that physician or immediate family member has a financial relationship with an entity. So what are we talking about when we're talking about this financial relationship piece? A financial relationship under Stark is a direct or indirect ownership or investment interest, or a compensation arrangement. So ownership or investment interest, we're thinking about physician or immediate family member ownership in that entity, or we're talking about a compensation arrangement. And typically, the big ones we see are things like physician employment agreements, call coverage agreements with physicians, other professional services agreements or personal services agreements. Sometimes we can have real estate leases with physicians that implicate Stark. So that's really kind of the bubble we're thinking about here. And then any of those relationships are in or with the entity that is providing designated health services. And so now that we've been through the first two bubbles, so we have our physician or immediate family member, they have a financial relationship with an entity. Now we have to have that physician referring or making referrals to that entity. So when we get to this piece and we're thinking about the definition of referral, I like to back up for 1 minute and think about really what was the government thinking and intending when they enacted the Stark Law. And one of its main goals is really to prohibit overutilization and the generation of quote unquote extra referrals by physicians for financial gain. So really we're trying to protect government dollars from being spent inappropriately to generate financial gain among folks who are able to create referrals. So when we think about referral for Stark Law to apply, we have one, that financial relationship, and then we have two, that referral piece between the physician and the entity providing designated health services. So with that, we get into the actual Stark definition of referral, which is a very broad definition. So it's the request by a physician for the ordering of or the certifying or recertifying of the need for any designated health services that are payable in whole or in part by Medicare, Medicaid. And so we get this very broad definition, and then Stark gives us a couple of ways and a couple of kind of other definitions of what a referral is not. So the first is that this referral definition, it does not include designated health services that are personally performed by the referring or ordering physician. So services that are provided by that physician, that is not a referral in and of itself. The second is there is a group of specific physician specialties, so radiologists, pathologists, and radiation oncologists. There are certain carve-outs from the referral definition under certain circumstances for those types of physicians for services that are provided pursuant to a request for consultation. So when we think about that, for example, in terms of radiology, we think about that radiologist may be performing a read of an image, but that referral actually comes from a patient's primary care physician or another specialty provider. That radiologist is not the one in the position to generate the referral, and therefore we have a specific and narrow carve out for some of those consultative services. And then lastly, we get into our final rightmost arrow over here, and this is that we are talking about a specific enumerated set of healthcare services called designated health services, or DHS, that are paid for by Medicare or Medicaid. So what do we mean when we say DHS? We have them listed on the slide here. It is an exhaustive enumerated list of healthcare services. So you can see up there, we're including clinical lab services, physical therapy, OT, radiology and imaging, durable medical equipment, inpatient and outpatient hospital services, outpatient prescription drugs. So even though we have this exhaustive and specifically enumerated list, we're hitting quite a broad range of health services within it. And so if we go to this slide, just coming back to bring these definitions together, we have over here our physician, so remember MD, DO, dental oral surgeon, etc., or their immediate family member, husband, wife, sibling, in-laws, step siblings. To have a financial relationship, so that ownership or investment interest or compensation arrangement with an entity, and then refer to that entity for any of those designated health services that were listed on the previous slide paid for by Medicare or Medicaid, unless we have that financial relationship meet an exception to the Stark Law. So now I'm going to turn it over to my colleague, Katherine, who can walk us through some of the basics of those exceptions and how they work.
Thank you, Kerry, for that great overview of the Stark Law and its key definitions. And thank you again, everyone, for joining us today. So we're going to go ahead and move on to the Stark Law's exceptions. And as for how these exceptions work, the Stark Law's exceptions are based on the type of financial relationship. So as you can see, there are 3 different categories of exceptions, some that apply only to an ownership interest, some that apply to a compensation arrangement, and some that apply to both. So it's important to know these distinctions because when reviewing a particular arrangement or when structuring an arrangement, it's imperative to use the correct type of exception. And with Stark, you have to meet a Stark exception and you have to satisfy every element of the exception because, as Kerry said, Stark is a strict liability statute and there's no intent component like there is with the anti-kickback statute. So just a couple of important points to remember about the exceptions on this slide. One being that you have to meet each of the criteria of an exception or the activity will not be covered by the exception. Then another thing to note is that not only do you have to meet each element of the applicable Stark exception, but each and every financial relationship that's subject to Stark has to meet an exception in order to avoid a Stark violation and any penalties that follow. So if we go to the next slide, since there are so many exceptions to Stark, rather than going through all of them, and we will highlight a few of the commonly used ones in just a minute, but we thought it'd be worthwhile to discuss first some of the most common elements of most Stark exceptions. And of course, there are going to be some caveats and exceptions to exceptions, but generally speaking, in order to comply with a Stark exception, an arrangement has to do the 6 things that are set out on this slide. So first of all, it has to be in writing, except for the employment exception, which actually doesn't require the arrangement to be in writing, but we still recommend that as a practical matter. So that's an example of one of these exceptions to an exception. But the next one is it has to be signed by all the parties in a timely manner. It has to describe the specific items or services that'll be provided. The compensation or remuneration has to be fair market value. It can't take into account the volume or value of referrals from the referring physician or entity, and the agreement terms have to be commercially reasonable. So if we move on to the next slide, we have some examples of ownership interest exceptions only. And I don't know that we use these too often in our practices unless maybe the arrangement involves a physician-owned hospital. But if we move on to the next slide, we'll see some of the compensation arrangement exceptions. And a few that we do use frequently are rental of office space or equipment, bona fide employment. So those are pretty self-explanatory. Some others that we use more frequently are personal services and fair market value. Those are ones that you would typically use for agreements with an independent contractor, whether it's a medical director administrative type of agreement or clinical agreements with someone who's not an employee. So those types of arrangements. Some other common ones that are used in a hospital setting are the non-monetary compensation exception or medical staff incidental benefits exception. And if you go on to the next slide, there are a few more compensation exceptions that you can see here. For example, one that was added recently in the new Stark regulations that became effective in 2021 is the limited remuneration exception. And that one is a new exception for arrangements that are less than $5,270 in the aggregate for calendar year 2022. So that's a number that can vary by year. And that's one that's very helpful in terms of providing some greater flexibility for organizations, as well as from a compliance standpoint, since it'll protect those certain small de minimis arrangements. For example, a physician standing in for a physician medical director and there was no written contract available, so those types of arrangements. And now I will turn things over to my colleague Keith to discuss some of the exceptions that apply to both ownership interests and compensation arrangements, since there are a couple there that are used pretty frequently and have some important concepts attached to them.
Thanks, Katherine. I really appreciate it. Yes, Katherine mentioned, again, she went through the compensation only exceptions, the ownership only exceptions, and what we're looking at here are exceptions that apply regardless of whether you have an ownership interest or a compensation arrangement with the entity. The first two, the physician services and the in-office ancillary services exceptions, those are available primarily to practices that meet the definition of a group practice. An example of the in-office ancillary services exception, it allows physicians to order certain ancillary services, DHS services, like laboratory services, imaging, physical therapy, that are performed within the group practice as long as certain conditions are met. Those conditions include requirements as to who provides or supervises the service, at what locations the services are provided, and by whom the services are billed. We'll get in a little bit more into the group practice definition in just a moment, but other exceptions that fit within this category include exceptions for referrals made and services provided in an academic medical center setting, implants furnished in an ASC, EPO and other dialysis-related drugs that are furnished in or by an ESRD facility, certain preventive screening tests and vaccines, eyeglasses and contact lenses following cataract surgery, and intrafamily rural referrals. Now, as I mentioned, we're going to get a little bit into group practice. Again, this is a basic, so we're not going to get too deep into the weeds. But essentially, there are certain Stark exceptions that are available only when a physician practice qualifies as a group practice under Stark. Those most notably physician services and in-office ancillary services exception. Qualifying as a group practice requires the practice entity to adhere to certain legal and business structure requirements. But in general, the group practice requirements are structured to ensure that the entity operates as a fully integrated medical practice and not as a loose confederation of otherwise independent physicians. What are those group practice requirements? Well, generally, there are 8 or 9 of those. We're going to walk through them a little bit. The first one is the practice must be a single legal entity operated primarily for a purpose of being a group practice. So, for example, a hospital cannot itself be a group practice, but a hospital can own an entity that qualifies as a group practice. Practice must also have at least 2 physicians who are members of the group practice, which means the physicians are either owners or employees of the practice or both. It's important to understand that the group practice requirements distinguish between a member of the group and a physician in the group. Therefore, while an independent contractor physician can qualify as a physician in the group and receive profit shares and productivity bonuses, they are not considered to be a member of the group for purposes of assessing the entity's compliance with many of the conditions of eligibility. For example, each group member must furnish substantially his or her full range of patient care services through the group practice. This means that if a group member provides any patient care services outside of the group, then the services provided by the physician in both settings must be comparable in scope in order to meet this test. Again, keep in mind that this condition does not apply to independent contractors. Also, substantially all of the patient care services furnished by members of the group must be furnished through the group and billed under a billing number assigned to the group. For purposes of this standard, substantially all means at least 75%. Like the full range test, the patient care services test does not apply to independent contractor physicians because they're not considered to be members of the group. Also, time spent by a group member providing services in a designated health professional shortage area are excluded from the calculation. Members of the group must personally conduct no less than 75% of the physician-patient encounters of the group. Thus, because any patient care encounters performed by independent contractors necessarily reduces the overall percentage of encounters performed by group members, significant use of independent contractors can negatively impact a practice's ability to qualify as a group practice. So group practices need to be cognizant of the mix of physician-patient encounters that are being provided by true members of the group, again, employees or owners versus independent contractors. The method for distributing expenses and income must be determined by the group before its receipt of payment from services to which that income and expense relate. Finally, the entity must operate as a unified business. This generally means that the group must have a centralized governing body which maintains effective control over the entity's assets and liabilities. Next, let's talk a little bit about how group practice status expands the methods by which the group can compensate a physician in the group. First, the group can compensate a physician based upon designated health services which are performed by other providers on an incident-to basis, incident to their personally performed services as part of a productivity bonus, even when the physician ordered those services. To the contrary, the employment and personal service exceptions do not allow compensation to be paid based upon designated health services performed by others. So that's an expansion in some of the advantages that the group practice provides in the ability to compensate. Group practices can also pay profit shares that indirectly, but not directly, take into account the physician's designated health service referrals. Profit shares can be distributed to all physicians in the group or to a component of the group consisting of at least 5 physicians. Please keep in mind that if a group practice forms a component of less than all of its physicians, then any profits to be distributed, which are attributable to those component members, must be distributed within that component. And what that really means is you cannot have service line specific components where you distribute profits from laboratory services in one, imaging services in another, and so on. The group practice rules do identify a few methods for allocating profits which CMS has deemed acceptable because they do not directly take into account the volume or value of referrals. A group can also use other methods not specifically identified by CMS so long as they are reasonable, verifiable, and do not directly relate to the volume or value of the physician's referrals. Note that the fair market value and commercially reasonable standards do not apply to bonuses and profit shares paid by group practices. This is a significant deviation from the employment and personal service exception requirements. Finally, many organizations have found group practice status to be especially helpful in structuring compensation arrangements which incentivize team-based care approaches. Now I'll turn it over to Alyssa to discuss some of the big 3 concepts.
Thanks, Keith. So now that we've laid that foundation of the Stark Law framework, as Keith mentioned, we do want to spend a few minutes on the recent regulatory changes to compensation concepts that we typically refer to as the big 3. And the big 3 are fair market value, commercial reasonableness, and the volume and value standard. These changes were published in November of 2020 and went into effect in January of 2021. So as we're looking at physician compensation issues, we have to always remember that the compensation should be fair market value, it needs to be commercially reasonable, and it can't vary based upon the volume or value of referrals between the parties. And that's not just in, the kind of this context, but just something to keep in mind. So now we're going to step through each of these 3 definitions and the regulatory guidance regarding them in a bit more detail. And sorry, Keith, if you could actually go back a slide, thank you. So of course, what does we have a modified definition of fair market value, and what does that mean? Of course, it requires that the compensation is consistent with an arm's length transaction that reflects the general market value of the arrangement. General market value now has its own standalone definition as well. And the final definition of fair market value has 3 components, one for general application, one for rental of equipment, and one for rental of office space. So it's important to make sure if you're looking at space rental arrangements or equipment rental arrangements that you're using the appropriate fair market value definition, and then the general application is kind of for everything else. For example, the definition of fair market value for general application is defined as the value in an arm's length transaction that's consistent with the general market value of the subject transaction. An important component here as well is that CMS removed references to the volume or value standard from the definition of fair market value. So that used to be kind of baked into that definition. And now CMS has noted that fair market value and the volume or value standard are separate and distinct requirements of Stark, and that they should be independently satisfied for each applicable Stark exception. So now you've kind of got those as 2 separate definitions, 2 separate components, instead of them being tied together so closely. CMS also noted in the commentary that fair market value may not always align with published valuation data sets. So it's always important to make sure that the arrangements and transactions that you're working on are fair market value given the specific facts and circumstances of the arrangement, like geography, productivity, all of that. CMS went into a lot of detail in the commentary about how, they're aware that there's kind of this industry standard and industry perception of, 75th percentile is kind of a safe place to be. And if you're under the 75th percentile, you don't necessarily have to worry about things. And CMS kind of nicely, but still said, we're not really sure where this came from. That's not anything we've ever said. You know, there could be arrangements that are under the 75th percentile that are still outside of fair market value for the services that that particular physician is actually providing. Conversely, they also said that there may be instances where an arrangement is outside of the survey data, but is still fair market value due to specific facts and circumstances associated with that individual physician and the market that they're in. So that is helpful, but it's just something to keep in mind that maybe kind of those published data sets don't have as much clear-cut reliability as maybe we had once thought. So moving on now from modifications to fair market value definition and to focus on commercial reasonableness. In order for an arrangement to be commercially reasonable, it must have a legitimate business purpose. CMS defined commercially reasonable as the particular arrangement furthers a legitimate business purpose of the parties and is sensible considering their characteristics, including size, type, scope, and specialty. CMS also clarified that an arrangement does not have to result in a profit in order to be commercially reasonable, and specifically noted a few specialties like burn units and psychiatry that often don't result in a profit for a provider or for a health system. I think that commentary from CMS is really helpful. We've seen over the years some enforcement actions in this space that point to profitability as a factor, in the sense of, oh, if you were losing money on this physician or on this service line, it must mean that you were paying for referrals, because why else would you do that? That's not commercially reasonable. And CMS has said, you know, that that's not necessarily the case. So that's great. And candidly, something that Hall Rinder had been working on kind of behind the scenes in our advocacy work for quite some time, is to kind of get away from that sense of profitability needing to be a component here. So we were really happy to see that in the commentary. Additionally, in the 2020 final rule commentary, one thing to note is CMS didn't really clarify what constitutes a legitimate business purpose. Instead, they noted that it is an objective standard and provided a few examples of things that can contribute to that, such as community need, timely access to healthcare services, licensure or regulatory obligations, including EMTALA, you know, the ability to provide charity care and improve care quality and healthcare outcomes in the community. So just something to keep in mind. There are a wide range of legitimate business purposes, but CMS didn't necessarily go so far as to define those. And then finally, moving on to the last of the big three, the volume or value standard. In the final rule, CMS clarified that compensation will only take into account the volume or value of referrals if the formula that is used to calculate the compensation includes the physician's referrals to the entity as a variable, which results in an increase or decrease in the physician's compensation that positively correlates with the number or value of the physician's referrals to the entity or other business generated for the entity. So that's kind of a mouthful. Effectively, what CMS said was that the formula itself has to include the volume or value of referrals as a variable. Again, we had seen over the years in enforcement actions, a lot of otherwise relatively mundane facts and circumstances have been portrayed in a way to try to show that the volume or value of referrals were taken into account in compensation. And CMS has said, no, it really needs to be a part of the formula. So I think that's another win for healthcare providers. Based on the commentary, I think it makes that a lot more clear cut. CMS also established some new special rules on compensation that address compensation to physicians as well as compensation from physicians, and when that compensation is deemed to take into account the volume or value of referrals. The key issue in both of these special rules, again, is whether or not there's a variable for the physician's designated health services referrals in the formula. And then we're going to briefly discuss directed referrals. So these are, required referrals or referral requirements. You may use these or may have seen these in your respective organizations. This has been something that's been permitted for some time, the ability to direct or require referrals. But CMS did modify this directed referral provision in the 2020 final rule. And so we've seen kind of some increased interest and activity in this space, because I think the updated regulations kind of reminded people that this was something that was out there that they could consider. This provision, permits an entity to direct a physician to refer to certain providers. There have to be 3 carve-outs, though, to any referral requirement: 1 for patient choice, 1 for requirements or directives from an insurer, and then 1 for the physician's medical judgment. Compensation can be conditioned on the satisfaction of the directed referral requirement now with this new guidance. However, you cannot base a decision on whether or not the arrangement exists. So hiring and firing decisions cannot be based on whether or not the physician follows the directed referral requirement. So you can make that a condition for elements of compensation, but you can't necessarily terminate someone because they choose to, because they fail to comply. One thing to keep in mind, or a couple of things to keep in mind, is that utilizing these directed referral requirements means that arrangements, particularly if they're employment agreements, are going to be subject to additional requirements that they otherwise wouldn't have under Stark, such as the agreement has to be in writing and the compensation must be set in advance, which typically are not requirements of employment arrangements under Stark. Candidly, because of this loss of contracting flexibility and the regulatory carve-outs that you have to any referral requirement for patient choice, physician's medical judgment, and insurance requirements, I personally try to encourage clients to choose another path, as I don't necessarily think that the potential organization benefits or benefits to the hospital or health system from these directed referral provisions outweigh the decreased flexibility that you have in employment agreements. I've seen time and time again, it typically comes up in the context of a provider that wants to amend an employment agreement, and maybe they, for example, have an employed physician who starts providing medical director services, and they want to provide additional compensation for those services, but maybe they don't think about amending the contract until several months later. Well, in a normal employment arrangement context, that's okay. You don't have to technically have your compensation arrangements set in advance and in writing. So you would be able to make that kind of retroactive and go back in time to add those medical director services to the employment relationship. But if you require referrals, it has to be set in advance and it has to be in writing. And so you're kind of stuck there and you don't have that same flexibility to go back in time and make those effective dates retroactive. And so that can cause, I've seen that cause a lot of frustration with clients when they're trying to be nimble with their employment arrangements specifically. So just something to keep in mind. Now I'm going to turn it over to Katherine to walk us through some of the relevant case law that will help provide us with some real life examples of the Stark Law in action and some lessons learned from those.
Thanks, Alyssa. So now we're going to switch gears and illustrate, as Alyssa said, just how some of these Stark Law concepts and possible violations play out in practice. And we're going to do that by walking through some of the key Stark Law cases. But before we discuss the cases, we did just want to quickly set the stage and note that most Stark Law violations are actually settled outside of court and don't result in formal litigation. So this is why you'll see that some of the dates that accompany the cases we're going to discuss are from several years ago, because there really aren't that many Stark Law case opinions out there. And one reason for this is CMS's Voluntary Self-Referral Disclosure Protocol, or SRDP, which allows providers and suppliers to self-disclose actual or potential Stark Law violations. Now, CMS publishes yearly data on the number of settlements as well as the corresponding financial information. And as you can see on this slide, CMS reported 369 SRDP settlements as of December 31st, 2020. And you can see kind of the range of the settlement amounts, and most being below $150,000. So it's a somewhat lengthy process, and there's currently a backlog at CMS, but settlements do typically result in payments being significantly lower than the potential financial exposure, which you'll see some examples of in just a few minutes. But this is one avenue for resolving actual or potential Stark violations. And if we go to the next slide, as for the cases that we're about to discuss, these are litigated through the False Claims Act. And just to provide a very brief overview, what the False Claims Act does is it prohibits the submission of a false claim for payment, and it's punishable by a pretty sizable amount per claim, as well as treble damages, as Kerry mentioned in the beginning of the webinar. And as you can see in this diagram, there is a knowledge and intent component of a false claim, and you have to have that in conjunction with factually submitting a false claim or retaining an overpayment, so just something important to remember. Now, there are a lot of procedural aspects to the False Claims Act as well that we won't get into today, but the main thing to understand for our purposes is that the False Claims Act is used as a mechanism to file suit where the government or a private citizen can sue or bring suit against a healthcare provider or organization for violating Stark. And so the False Claims Act is a vehicle to do that. And you'll also see the term qui tam relator used a lot in the False Claims Act context. And just know that what that means is that's a private party who brings an action on the government's behalf, which is something that's permitted under the False Claims Act. So let's go ahead and take a look at some of the key Stark law cases, starting with United States versus Bradford Regional Medical Center. Now, just to give you some background, the qui tam relators here were physicians that practiced in the community, and the defendants were a hospital and two internists that owned a physician group LLC. And the group purchased a GE nuclear imaging camera for its office, and because the physicians were a major referral source to the hospital and accounted for a large portion of its nuclear imaging revenues, the hospital believed that the physician's purchase of the nuclear camera would be financially detrimental to the hospital. And since the physicians were also members of the hospital's medical staff, the hospital alleged that the physicians violated an internal policy against financial conflicts of interest and threatened to revoke the physician's privileges. And in an effort to resolve the issue, the hospital also subleased the GE camera from the group, and the group then leased a new camera, and that lease included a buyout obligation for amounts that the group owed on the original GE lease. And the hospital then guaranteed the group's buyout obligation, but this subsequent arrangement was never documented in writing. So there was never a lease or any kind of writing memorializing any kind of the arrangement in an agreement, for example. The hospital also requested that an accountant prepare a fair market value assessment of the sublease, and as part of this assessment, the accountant concluded that the amounts to be paid were reasonable and accounted for projected referrals in the fair market value opinion, and the hospital board then approved the sublease arrangement. So the court ruled in the outcome that as a matter of law, the agreements were a violation of Stark, and the outcome here was a pretty sizable multi-million-dollar settlement between the hospital and the government, and the hospital also had to pay the relator's attorney fees and expenses, which were over $500,000. So if we go to the next slide, just to talk about the takeaway here, is that there's both a technical analysis and an intent analysis. And the point here really is that all the parties did something wrong. For example, they didn't have proper documentation of the sublease from a technical standpoint, so that's clearly something that should have been documented. But they probably wouldn't have ended up where they did just because of that. The case likely would have settled long before that, but really what got them into trouble were these other items related to intent, such as the threat to revoke privileges, the fair market value opinion accounting for the referral business. So it's really these facts that get a relator's attention or a jury's attention, because even though with Stark, intent doesn't really matter, it's important to be careful about things like communication, because that's really what gets you into trouble. Because the point here being, they really wouldn't have needed to end up where they had just because of the technical violation, but because of all these other intent-based elements. That's why they ended up in so much trouble. So if we move on to the next case, which is United States versus Toomey Regional Medical Center, Toomey is a very dynamic case with lots of facts and components, and we're not going to be able to get into every detail in the interest of time, but we'll just try to boil it down to some of the key facts as best as we can. So this case stems back to 2003, when Toomey learned that several specialty physicians were moving their surgical procedures in office instead of at Toomey's hospital. And in response, the government alleged that Toomey employed the physicians as part-time employees to avoid a reduction in surgical case volume. So the employment contracts, they required physicians to perform procedures at Toomey, and the physician salaries were based on net cash income for outpatient procedures. And so one of the physicians filed a qui tam lawsuit against Toomey after his negotiations with the hospital went south, alleging that the physician agreements violated Stark and the False Claims Act for being above fair market value and taking into account the volume or value of referrals. So as you can see on the slide, essentially the compensation structure had a number of problematic components. And if we go on to the next slide, you'll see that quite a bit of litigation ensued, with the initial decision finding just a Stark law violation being vacated, but a second decision finding Toomey in violation of both the Stark law and the False Claims Act, that was upheld. Now, one takeaway is the sizability of the settlement, $72.4 million, and as you can see on the slide, the verdict was much higher. And about a year after the settlement, also, the DOJ announced that the former CEO of Toomey would personally pay $1 million to settle allegations of his involvement in the health system's violations. And he was also excluded from participating in federal healthcare programs for 4 years. So that just goes to illustrate not only the devastating financial consequences on the organization, but also on the individuals at the helm of the organization being exposed to that liability as well. So if we go to the next slide, just to summarize the analysis here. So in addition to the technical violations listed here, such as those related to fair market value and commercial reasonableness, those standards that Alyssa mentioned earlier, where they really got in trouble, again, was more based on the intent factors. So for example, there were board meetings, board minute recordings where the management and board members made certain comments regarding the intent and strategy of the contracts. So that was a lot of what really got the parties in trouble here. And like I said, there's a lot more to Toomey, but in the interest of time, we'll move on to our next case, which is United States versus Halifax Hospital Medical Center. So this case involved a whistleblower complaint that was filed by the former compliance officer and physician services director for Halifax, alleging that the Halifax's contracts with several of its oncologists violated the Stark law. And specifically, the allegations were that the contracts provided an incentive bonus for physicians who ordered higher cost prescription medications and tests, which Halifax then billed to Medicare. And Halifax was also alleged to have paid several of its neurosurgeons more than fair market value compensations. So essentially, there were alleged violations of all three concepts that Alyssa mentioned earlier: the fair market value, commercial reasonableness, and taking into account the volume or value of referrals concepts. So if we go to the next slide, you'll see that the court ruled that those oncology bonus compensation payments were in violation of Stark, and the case was set to go to trial on the rest of the government's contentions, but immediately prior to the trial, the parties settled. And Halifax is notable because had the case gone to trial, it would have been the largest potential damages ever seen in a whistleblower case against a single hospital, because the damages there had the potential to reach over $1 billion. And as you can see, the settlement still was pretty sizable. And if we go on to the next slide, again, we have this distinction between the technical and the intent-based elements as well, and we won't go through them all in the interest of time, but again, just wanted to point out this recurring theme in the intent component of internal communications. So again, this really underscores the importance of being very careful with any kind of communications when it comes to Stark. And finally, for our last case, we have United States versus All Children's Health System. And in this case, the relator was the former director of operations, and she had created a new compensation plan for the physicians at the hospital that did not allow the compensation to exceed the 75th percentile of survey data. So the relator here alleged various Stark Law and False Claims Act violations that were related to physician compensation, such as failure to follow the compensation plan, compensation that exceeded fair market value, and an alleged hiring spree by management of physicians in order to bring more referrals to the hospital that involved some aggressive recruiting tactics. So for example, to induce the physicians to work for the hospital, there were allegations that the doctors were offered bonuses based on the number of procedures performed at the hospital. And the hospital also allegedly offered other perks and financial incentives, and many physicians were paid above fair market value. So lots of potentially problematic aspects here. But what makes this case distinguishable from all the other cases is that this is the threshold case where the court ruled that Stark applies to Medicaid as well. So if we go to the next slide, you'll see that the case resulted in a $7 million settlement, and the federal government declined to intervene in the case. However, it did issue a statement of interest concluding that the Stark Law applies to both state Medicaid and Medicare. So this case is also an example where the government declined to intervene, but the relator was still able to proceed on their own and obtain a sizable settlement. So if we go on to the next slide, as you can see, we have these distinct technical and intent analysis here again, with the payment of the considerable number of physicians above fair market value as an example of the technical violations, then the recruiting tactics as part of the intent analysis, But in the interest of time, I'm going to go ahead and turn things back over to Steve to wrap things up for us and move on to the question and answer portion of our webinar.
Thank you so much, and a great presentation. And we do have some questions that have come in. And since you were going through those cases, I think that prompted one of these questions. Obviously, no provider is going to instruct their employees they can't talk to government investigators. That's obstruction of justice. However, every organization does have the right, I hope, it used to be when I was in hospitals, if the OIG or someone comes in, especially unexpectedly, and approaches people to ask questions, you do have the right to say, we will certainly cooperate, but we want our chief legal counsel here with us. Is that correct?
Yes, so certainly we would want to refer those inquiries to the legal department, as well as most organizations have a compliance department that typically has a protocol or a manner in which they would want to respond to these types of inquiries. And I don't know if Keith, Alyssa, or Kerry, if you would like to jump in with any of your experience dealing with these types of issues, if you have any other recommendations when faced with these types of questions or inquiries, if you'd like to jump in as well.
So, Katherine, this is Kerry. Quickly, from the compliance perspective, most organizations will have some sort of investigations procedure or policy, and in that, you know, one of the things is there might be a contact person listed, and it's really a best practice if an investigator comes to the door to have someone immediately contact that key contact person, ask investigators if it's okay to wait for that person to arrive. But I think the key critical piece here is that, you know, no employees should be interfering. So if that investigator says no, then they shouldn't get in the way of what the investigator is doing. However, they might want to get a pad of paper or something to record everything that that investigator is looking at and documents that are being taken.
Thanks. Another question is, at the outset in the presentation, you mentioned the government, Medicare and Medicaid. Does STARK and false claims, this is the question, also apply to other government programs, such as TRICARE?
The coverage of the STARK law applies to the concept of the designated health services, which are payable in whole or in part by Medicare or Medicaid. Now, the interesting thing is that the prohibition is if the STARK law applies, you cannot bill any payer for those services. So the answer is really, it does not necessarily apply directly to TRICARE or to other governmental programs, but the prohibition, if there is a prohibited financial relationship, it doesn't mean an exception, and the designated health services are payable by Medicare or Medicaid, then for example, if Medicare was secondary to another governmental payer, you could not bill that other governmental payer without violating the STARK law.
Great. Here's another question. Would anesthesia services performed obviously for surgery be included as a designated health service as an in or outpatient hospital service?
Yeah, this is Alyssa.
Yeah, go ahead.
Sorry. Go ahead, Keith.
Oh, I'm sorry. You go ahead.
We're both so excited to answer this question. So with anesthesia, it can be a little tricky. The anesthesia services themselves are not necessarily things that would typically be DHS, but designated health services do include all inpatient and outpatient hospital services. Where we typically get a break, so to speak, from the STARK law with anesthesia is most anesthesiologists, unless they have a separate pain management practice, most anesthesiologists are not actually making referrals to the hospital. So while they may be providing services that kind of fall within that DHS umbrella, their arrangements may not really implicate Stark if they're not making referrals. Now, if they have a significant pain management practice kind of outside of just their inpatient, outpatient anesthesia services, that can be a little different. But if they're really just kind of in that inpatient, outpatient anesthesia, supporting surgical cases, that sort of, and other procedures, that sort of thing, typically you won't necessarily run into Stark issues with those arrangements because they're not really making referrals to the hospital.
Great. Here's another great question. And for the attorneys on the phone that aren't here in DFW, we have 4 main counties that are really urban. And then we're surrounded outside of that with rural areas. Great question here. Fair market value, candidly, can be a gray area. How do you suggest you review remuneration where there is an area that's rural but also is surrounded by urban care?
Yeah, so I think as Alyssa went into earlier, you can take into factors such as where the location is that you're asking the physician to practice and potentially relocate their residents to, and you can take into that factor, or as you are documenting what you are paying, you can include within the factors that you use to determine what the payment is, the desirability of the location. What are the hardships or lack of hardships that are there that might require you to increase compensation? How hard is it to get physicians to agree to move to the area? DFW is a really weird location in the sense that it is, we've got 7+ million people living in the Metroplex, but there are some urban, rural areas around there. But what we really advise is that you look at, you use factors that relate to the specific geographic location. How much are the houses going for in that area? Is it cheaper to buy a house where you are asking them to relocate than it is in another urban area? Is it difficult for you to offer a certain rate to get people to accept that rate and move in? So you can use the fact that you are in a rural area. You can use the fact that it may be harder to recruit to that area, but on the other hand, it may be cheaper to live in that area, so you have to weigh those factors.
Great. Here's another great question. What about the rule of 5 in regards to sharing ancillary services revenue?
Yeah, that's Steve, that is the rule of 5 is what we were referring to in here as a component of the group. You can certainly, as part of a group practice, when you offer a profit share, you can create a component of 5 or more physicians. It has to be at least 5 physicians. But the change that has come about is CMS clarified within its rules, and I think it's now been about a year and a half ago, that when you have that component, all of the profits that you are going to distribute from designated health services to that component, they have to be distributed within that component. And what that really means is you can no longer have a laboratory profits component pool, and then an imaging profits component pool. So if you are, and it does not obligate you to distribute all of your DHS profits, but if you're going to, all of the profits that are attributable to the referrals of the physicians within that component have to be distributed within that component.
Great. Thanks. That's most of the questions we've gotten, but I'm going to throw one in myself. I'm so old, I remember when Pete Stark introduced the Stark Law. Can any of you kind of just, especially for the much younger people involved in this today, what really prompted Pete Stark to enact or at least propose the Stark Law. Any thoughts on that?
Alyssa, do you have any specific thoughts, or do you want me to just jump in?
Sure. So I think, certainly when Stark was originally enacted, it was really only specific to physician-owned or physician relationships with laboratory services, and obviously has expanded, much more broadly beyond that now. And we've seen it kind of ebb and flow over the years as far as some things that used to be prohibited are now permitted and vice versa. Ultimately, I think it's, the intent behind it is wanting to make sure that physicians and healthcare providers and healthcare organizations are making medical decisions based on what is best for patient care, right? And not the financial benefit that they may or may not have from it. But I think everyone on this call could also agree that isn't always the reality, right? That some conduct is restricted or prohibited that maybe shouldn't be, or there are still some things that you can do where every once in a while it's like, oh, well, kind of surprised. Feels like that maybe shouldn't be okay, but it does comply with the law. So I certainly don't think anyone would say it's perfect. I don't think anyone would say it's at times logical. But I think that was kind of the original intent. But Keith, I welcome any thoughts you have too.
So I absolutely agree. And the only thing I would add is it gave the government an administrative remedy for trying to stop those arrangements that are most likely to be overutilized. And by that, I mean, as Alyssa mentioned, it started with clinical laboratory services, which you can take one draw of blood and order 100 different lab tests. And so it was really trying to, in my mind, capture that group of services that were easy to overutilize without creating significant patient discomfort or injury. And so it was trying to create a remedy to keep physicians from using financial means to justify their medical care and really focusing more on what's best for the patient.
Great. We do have one final question that just came in, and so I'm gonna throw this to you, Keith, and you can have anyone answer it, and then you folks can go ahead and give your closing thoughts to finish an excellent webinar. But you touched on this in the presentation, and I certainly want to thank you, Keith, and Alyssa, and Katherine, and Kerry for a great presentation. But it's worth repeating. What frequently do you, as attorneys, recommend for fair market reevaluation after the initial valuation for provider comp and space lease agreements? How often should it be done?
Yeah, so oh, sorry, Keith.
No, go ahead, Alyssa. Your turn.
I was just going to say, in my experience, if you're using an outside valuation firm, oftentimes their reports will actually have, they don't necessarily always phrase it as an expiration date, right? But a period of time that they kind of guarantee that that's fair market value. So if you're in that situation, then certainly I think having it reevaluated once that period is coming to a close makes a lot of sense to continue to have that assurance, especially if you feel like there have been changes in the market one way or the other. Otherwise, I think, if you're kind of assessing fair market value internally, doing a check-in every few years, if it's an arrangement that you think is at the higher end of a fair market value range, either through your own internal assessments or because you have an opinion that states as such, then those, there may be a few that make sense to evaluate more frequently. I work with a client who has a few physicians that are kind of right there at the top of the range, and so they actually have an outside opinion performed annually every year, just to make sure that they're still within that range, because they're pretty close to the top there of what the client is comfortable with. But for your average, kind of middle of the road compensation arrangement with a physician. I think every couple to few years is sufficient.
Thank you.
I
Keith, I'm sorry, go ahead.
Steve. I was just going to say I would agree, and it also we've got to remember that many of the organizations that are probably on here listening and in the DFW area also have to comply with intermediate sanctions rules as tax exempt entities. And so, in my opinion, Alyssa, everything she said is absolutely right. I think depending upon the size of your organization, having a good compensation plan and policy will help you to do that. But every couple of years, and if we get something like we did with the pandemic that fundamentally shifts the market and the values in the market, it's probably a good idea to reassess during that period as well.
That's an excellent point. Well, Keith, you and Kerry and Alyssa and Katherine have done a great job, and we want to thank you, and we'll let you have the final word for your closing thoughts.
Great. Thanks, Steve. And I do want to appreciate Alyssa, Katherine, and Kerry for their participation on this. We have a wonderful team who is very skilled at Stark Law analysis. We appreciate everyone taking time out of their day to listen in on us, and would encourage you that if you do have any questions, that you reach out to us, because we'd be glad to help out. But thank you again, and we hope you have a wonderful rest of the day.
Thank you very much. This webinar is now concluded. Everyone, please have a nice evening.